FDA now has the authority to collect certain fees. These are what they are: fees related to mandatory recall. That is, if a facility is responsible for complying with an order issued by the commissioner to recall, that person has to pay a fee. Remember, this is a company that's already gotten through and passed the process of a voluntary recall. FDA wasn't happy with it, so FDA went to order a cease distribution, had the hearing. At the end of the hearing, FDA wasn't happy with it, and so they mandated the recall from the commissioner. So this is an FDA that's not happy with somebody. And so at that point, Congress says, well, if you're going to get that far, then the responsible party will have to pay the fee. The responsible party in that case is a person it's connected to the person who's responsible for submitting the facility's registration. So it would be the owner, agent, owner, operator, or agent in charge of the food facility would be subject to the fee. Secondly, there's a reinspection provision. If a company has to be reinspected, a food facility or an imported article, then FDA can charge a fee for that second inspection if the second inspection happens in the same fiscal year. So, in this case, it's a importer or a facility or the U.S. agent of a foreign facility. It would be a person responsible for covering the costs associated with a reinspection. And this reinspection fee occurs if FDA has to go back because they had a problem the first time, and their going back happens within the same fiscal year, then you basically pay the cost of that inspection. An importer is also, this is a strange one, the importer is required to cover all the costs, including administrative costs, associated with re-inspecting the imported food. Now, I say that because the inspection that Congress is talking about here is an inspection or an examination that comes under 801 of the Act. 801 of the Act is where FDA's import authorities lie, and the only inspections that happen under 801 are food shipment inspections. FDA doesn't have authority to inspect a facility under 801, only imported food. So this reimportation is going to a reinspection of an imported article. What's not clear is if it's meant to hit importers who bring in a product where there was a problem with the product and FDA has to reinspect that article again, that same article in that shipment. Or if Congress means to say, I import Article A as a food, FDA inspects it and it's in violation of the law, I import Article A as a food in a week, FDA has to inspect it again because the prior inspection, can they charge me for that one? And that's not clear. The statute doesn't make that very clear, so this is something definitely to watch as an importer as to where FDA is going to start trying to get those fees. Importer in this case is not defined at all. Interestingly enough, FDA didn't bother to define who the importer was. I think because the Qualified Importer Program is a fee program also, that probably tells me they mean to use that importer definition, which is a very broad one. It's a very broad definition for importer. So that's, I think, significant. In both cases for this reinspection fee, administrative costs are built into the fee, and they include arranging, conducting, and evaluating the results of the reinspection, and get this, assessing and collecting reinspection fees. That would be built into FDA's fee, which is FDA billing you for the privilege of billing you, which is something that if I tried to do, I would be probably disbarred because it would be unethical. But Congress is telling FDA, if they have to bill you, if you have to bill somebody, bill them for the time it takes you to bill them too. So there you go. Fourth, another group here, importers that participate in the voluntary qualified importer program pay a fee for service. It's an annual fee. Presumably that's the one that I think that also probably helps us define who importer is, because there's at least a definition there that talks about persons who bring food into the customs territory of the United States. That probably tells us who an importer is for the other one, the reinspection of the imported article, or who's responsible for the fee, which is a pretty broad group of people that FDA could reach. Whistleblower protection, entities engaged in the food industry now cannot take any punitive action against an employee who's providing information about or refusing to participate in any action that relates to violating the Food, Drug, Cosmetic Act with respect to the food. This is not for drugs or devices, it's for food only, but it's significant. That people should be cautious of if someone is starting to report something and there's any adverse employee action taken, then there are Department of Labor provisions that would enable that employee to, first of all, some significant civil penalties and fines, but also protection from the federal government of the employee.